Hi, everyone. Thanks so much for being here tonight. My name is Lisa Hack. I am a certified divorce coach, narcissistic abuse recovery coach, and grief coach. And I specialize in working with clients going through high complex divorces with high conflict partners. I work with people at the intersection of creating the right strategy, somatic healing, emotional regulation, and rebalancing your nervous system and nervous system regulation. I am currently in Rome, so I am recording this so they can play it for you tonight. And first, I just want to thank you all for being here. I know coming on and hitting play and being in these sessions sometimes can be a really challenging place to get to. We have kids, we have jobs, we have lives, and we have so much going on. So thank you for taking the time for you. And thank you for joining us here at Vesta. I love to start each session off with a little breath work, a little nervous system regulation, because, like I just said, it is really hard to get here. You've likely had an exhausting, stressful day. So, before we dive in, before we get started, I am going to invite you all to close your eyes for a moment. And we can't see you, your pictures are not on our screen. Don't worry about that. And you don't even have to close your eyes if you do not want to. I am actually going to turn my camera off for this part just so I am not distracting to you. So I am going to invite everyone to close your eyes if that feels comfortable and safe for you, and just let yourself start to get really deep in your breath, really grounded, taking a moment to be present. This may be your first moment all day or maybe all week that you've felt grounded and present. Start to take some nice deep inhales and nice deep exhales now. Just letting the breath fill the lungs, releasing all the air from the lungs. Just staying with those nice deep inhales and nice deep exhales, however they feel good to you. And as you're breathing, let's start to feel your feet nice and heavy and nice and grounded into the floor or the surface underneath you. Maybe noticing you even have feet. Starting to notice your body and the weight of your body in the chair, the surface underneath you and behind you. Starting to notice maybe any noises you hear in your room or outside of your home other than my voice. Starting to notice the temperature of your body. Is it warm? Is it cold? Is it perfect? Does it feel pretty neutral? Now we're going to invite you to change your breath just a little bit. We are going to change your breath and to go into some 5, 2, 8 breaths. So what that means is we're going to inhale for 5, hold for a count of 2, and exhale for a count of 8. And now, just for a few moments, let's allow you to continue in those 5 to 8 breaths at your own pace. Letting yourself maybe feel your nervous system come down. Maybe your breath gets a little deeper. Maybe you're starting to feel a little more at peace and a little more present. And as you're doing these 5 to 8 breaths, just starting to notice what's happening inside your body. Is it feeling calm? Or maybe there's a place in your body that feels tight and tense, and that's okay too. We can just let that tight, tense feeling allow it some space to be there. Actually, now noticing a sensation, any sensation, whether it's a positive sensation or maybe it's a tight, tense sensation, maybe in our neck or our chest or our stomach, let's all allow ourselves to just sit in that for a minute. Sit with that sensation and notice whatever you notice. Often, when we're feeling a sensation in our body, our lives are so busy, we tend to be used to just stuffing things down. So we push those sensations away. But for right now, for this moment, let's give that sensation some space and just notice what you notice. If thoughts start to come to your mind, it's okay. That's what our mind is meant there to do. So just imagine these thoughts are passing by like little clouds in front of your face. Just allow them to be there. Don't push them away. Just allow them some space. But let's go back to those sensations now, whatever they are, and just allow them to be there. Sit with that sensation that you're feeling in your body. Maybe we notice on a scale of 1 to 10 how strong that sensation is. And just let it be whatever it is. Noticing whatever you notice. And just allowing yourself to lean into that for a moment. Staying with those 5 to 8 breaths, or if it feels better, you can go back to those deep breaths. I'm just going to invite you to sit with us for just a minute longer, just to be aware of our time tonight. Letting yourself sit with that sensation and that breath for just a minute longer. And while we're in this space, I want to let you know these 5 to 8 breaths that we're doing here right now tonight is a great way if you're ever feeling anxiousness creeping, if you're ever feeling stressed, if you're ever just feeling that spirally feeling we often feel in our head, especially when we're going through divorce. If you allow yourself to do these 5 to 8 breaths, and you can literally do them wherever you are and whenever you want, what this specific breath pattern does is it signals to your nervous system that you are safe in that moment. Our nervous system is built in a way to let us run away from a bear if it's chasing us, to run away from danger. And our nervous system doesn't understand emotional danger versus physical danger. So when you are breathing in this 5 to 8 pattern, we actually would not be able to run far or fast from a bear. So if we change our breathing into this pattern, we are able to signal to our nervous system, we don't need to run right now. We're okay right now. And it's just a little life hack, a little breath hack, a way to quiet the mind, to quiet the body, and to allow the nervous system to breathe. So I'm going to invite you now to just start to begin to come back to the room, maybe wiggling our fingers, wiggling our toes a little bit, wiggling our body in our chair, allowing your eyes to open when they're ready to open, and come back to us whenever you're ready. Giving our nervous system a moment to wake up just so we don't shock it too much. Many of the people I am working with are navigating legal decisions while their heads are in a constant state of stress, a constant state of survival mode, a constant state of fight or flight. And when that's happening, even if we have the best, most absolute best legal advice in a legal team, it's hard to absorb it all. So my role is to help clients and people slow things down, to take a breath, maybe like we just did, to regulate so they can think clearly, so they can make thoughtful decisions and practical decisions, less from emotional place of the divorce and more from the lifelong impact the divorce may have on their life and their children's life. And that brings us to custody. The custody often for people and the parenting plans are the most stressful parts of the divorce. They are the most emotional parts of your decisions around your divorce. And if you're facing that, you also may be facing the stress and emotion of maybe not being the one to be with your children every single day anymore, maybe not seeing them every day. And that can be really hard and very emotionally draining, especially when you're trying to think ahead. And maybe you are in a relationship with a toxic partner. So you're thinking about what is best for my children. How do I protect my children? And how do I move forward with this divorce? And that's why we're all here tonight. We are going to help you with all the logistics and all the aspects of that. And you are going to have time to ask questions at the end. One thing that can be helpful to remember when you're creating your parenting plan, your access plan, your custody arrangements, whatever it's called where you live, is that it's not set in stone. It doesn't have to be forever. Custody and parenting plans can change. They're actually one of the only things that can change in divorce once we sign on the dotted line. So with that said, we're not, say our children are 2, we're not planning far out. We don't need to plan this until they're 18 because it will likely change. Their schedules change. Their lives, their day-to-day lives change. Your day-to-day life is going to change. But I often encourage my clients to think about the next 2 years, not just this moment, not just what's happening in this moment, but for the next 2 years, what is likely to work for you as well as your children? When we're creating it, coming from like a logic place as best we can, what works for your children's day-to-day schedules, for their school schedule, for their homework schedule, for their sleep schedule, all of that. So we can often find a lot of times feeling a lot of pressure just to get it done to move forward. So focusing on the here and now, and does what you're thinking about actually work? Another part I really like to encourage clients to think about is holidays, summers, school vacations. Think about what those look like now. Think about what you would like them to look like as this divorce moves forward and your life and future begin to move forward. Mother's Day, Father's Day, your children's birthdays, holidays. What works for you? What works for your traditions? Maybe what works for your soon to be ex partner's life and traditions, and trying to make it work so it works for you and especially for your children. The more detail you can put in a parenting plan, especially in a high complex, high conflict partner divorce, it's going to save you a lot of time and headaches later. Maybe where did the pickup and drops off take place? Maybe it's easier to do so they're transitioning to and from school or summer camp when possible, just to lower the conflict, lower the interaction with your ex, because those interactions can feel very difficult to the children in certain situations. Also, even though I just said parenting plans can be changed, it's also a good thing to think about, especially in high conflict, high complex divorces, that sometimes these partners that we're living can be a little manipulative and they know often maybe one parent more than the other's priorities are the children and the time with the children. And so we want to consider that. I have clients that come to me a lot and say, I will give up everything. I'll give up all the finances, all the investments if I can just have my kids every Christmas morning. Not sure a judge would go for that. Hopefully your attorney wouldn't allow that. But I have seen cases where the client was close to signing on that. And I caution you against that because, as I said, many things can't be changed once you signed on the dotted line, but parenting can. So it is likely that if you agree on a parenting plan that really works for you, that maybe doesn't work for them, or they weren't too agreeable to in the beginning, but you're using finances to negotiate that, they can go back after you sign on the dotted line and change that. And then you can go back and change the financials, but they can go back and change the parenting plan. So it's just something to think about if you find your soon to be ex partner using parenting as a negotiation tactic, maybe to get more of the finances, the home, or whatever. And also, as we talked, we want to design this around your children's lives. We also want to design your parenting plan around your life. Does it work for your work schedule, your commute schedule, your summer schedule? What's it going to look like as far as childcare, before and after school care? And is that doable? Because if you're running around and you're stressed and you can't manage, that is ultimately going to affect your kids. They want a mom, a dad, a parent who is emotionally regulated. That makes all the difference, especially going through this time. And that brings me to one more place. It's so hard to say goodbye to your kids on holidays, on breaks, even maybe part of the week. What are you going to do? The first time is very hard. It brings up the grief of the divorce. It brings up so much emotion. So I encourage you all, and I always encourage my clients, let's come up with a plan. What are you going to do during that time? Often we're just so exhausted, we want time to sleep and rest. Often, maybe you've been the primary parent, you've never had a moment to yourself. So thinking about things that are grounding for you, that are nervous system friendly for you. Maybe that's your time for self-care, even if that means meditating and going for a walk. Maybe it's your time to reconnect with friends, or maybe it's your time to just sit down with tea or wine and breathe and take a break. But especially in the beginning, I really encourage you to have a plan. Even if it's one thing, your kids are gone their first weekend, have one friend, you're meeting a family member for dinner. Having something, even if you make yourself a little schedule in your phone for the first couple days, the first couple weekends, just so you have a path forward. And it's also important if our kids ask, what did you do when I was gone? To let them know you had a plan, to let them know maybe you had some fun, to let them know the things you did. Of course, we all miss our kids, but when they are leaving, especially in the beginning to go visit the other parent, they tend to worry about the other parent. So often it's really important for them in their transition into this process to let them know that you're okay when they're not home. Maybe you're sad. Maybe you're upset. Maybe we don't tell them that. Maybe we let them know you're okay. You met a friend for coffee. You had a great time and you're okay, but you're also really happy to see them and you're happy that they're back. Before I hop off, I just in transition us to our next Vesta professional. I just want to give you a quick suggestion for the transitions. And this literally works for any age. Children, especially in the beginning, they have a little trouble transitioning from house to house, from home to home. It's hard. They're now in two separate homes with two separate parents, with two separate sets of rules. What's really helpful, I find, is like I said, the transition point at the school or somewhere other than the home is really helpful. When you're transitioning, instead of taking them, say, from the dad's house to the mom's house, if you can make a quick stop in the middle, even if it's you're stopping to grab gas, you're stopping at the grocery store, if it's beautiful out, stopping in the playground, taking them outside, taking them for a quick walk, just so they have a transition point between A and B, it really helps them to reset with you as the parent they're with now and your nervous system to reset. Another thing that works really well is having a transition box. Just like a little like Rubbermaid plastic box, shoebox size box, and you put it on your children's bed for when they get home. And it's just there for when they get home. And we have something for every of the five senses in it. Maybe there's a piece of chocolate, if they like chocolate. There's something that smells good. Maybe there's something that's soft and feels good, or maybe there's a stress ball. Maybe there's a picture or a book about something that they love. And I like it when people spread like a little cozy blanket under it too. Because children tend to need a minute when they come back from the other home. So it's just something that they can expect. There's something in there for every one of their five senses to just help them ground, be home, and reconnect with them and their nervous system. And then just put it away, put it on a shelf, tuck it away when they're done with it, and put it there next time the transition happens. I like it seems to work really well when you keep the things in the box the same for about a month, and then you can slowly transition the items out, maybe changing them one at a time. One thing I found extremely well too is to make your house smell the same when they come home. I know it sounds weird, but it's really helpful. So if you want to just put like some lavender in a diffuser in your kitchen or wherever you're walking into when you walk into your home, or any scent that really smells good and homey to you, have that scent going when they come home. And that scent will start to feel calming to them. It works for the neural pathways in the brain, and it really helps them to feel grounded and connected when they come into your home. And with that, I am going to hop off and pass this on to our next faster professional. You are welcome to reach out to me with any questions, any comments, with anything you need. I also have a parenting plan sample template to get you start thinking about some things. So I will pass that on to Mandy and email that to her in case she wants to send that off to all of you. You're welcome to reach out to me at any time.
Before we dive in, Marty and I are licensed in Massachusetts. And as I mentioned, we are a Massachusetts based hub. But we always have participants and registrants at our events who are from out of state. So, with that being said, the information we provide tonight, of course, is educational in nature, but it is based off of what we know as Massachusetts based attorneys. So, divorce and custody laws are state specific. So if you reside in another state, we do encourage you to consult with an attorney and a mediator who is licensed in your state because there could be specific nuances that you should be made aware of. Okay, so with that out of the way, let's get to it. So, child custody. In many states, including Massachusetts, family court judges are tasked with rendering custody decisions that are in the best interest of a child. But what exactly does that mean? Marty and I are going to get into some factors that are laid out in the laws of Massachusetts. But from the get go of this conversation, I just want to make it very plain and clear to everyone who's listening tonight that best interest of a child is a very subjective thing. It can mean something different to everybody. We all have our own opinions, biases, norms, our own lived experiences that we bring to a table. And judges in family court have wide discretion. So you could have a case with a certain set of facts and present it to two different judges. And it is very possible that you could end up with two different outcomes. And that is just the reality of family court. And we do our best as attorneys based off of our experience with similar fact patterns to help guide our client. But we can rarely, if ever, give guarantees on any of these types of situations. And this is a plug for alternative dispute resolution methods, like Marty is a mediator, which I'm a huge proponent of, and even settlement negotiations when you're advised by attorneys, because you have much more control over the terms of your parenting schedule and your legal custody, everything to do with your children if you are choosing those terms rather than a stranger, the judge, forcing those terms upon you. All right. There are two different types of custody. So I just want to make sure we're all on the same page about what we're talking about here. There is legal custody and physical custody. And within legal custody, there are two main components. The first one is the ability to make important decisions about your kids. I'm a mom of a 10 and 12-year-old, and these are things like making medical decisions for them, elective procedures, braces, anything to do with that. Should they get certain kinds of surgeries? Who should be their doctor? Academic decisions, where should they attend school? IEP decisions, things like that. And religious issues. What church should they attend? Should they be baptized? Those things. The second main component of legal custody is the ability to obtain your children's records. So, be able to get copies of their report cards, ability to get their medical records and dental records, and to speak with their providers. So, their doctors, their dentists, their therapists, if they have mental health providers, and their teachers, go to parent teacher conferences and the like. So, that is legal custody. Physical custody is, where does the child live? How do they spend their time between their two parents' homes once they're separated? And this is often referred to as a parenting time schedule. We used to call it visitation. That's out of fashion now. So it's more referred to as a parenting time schedule. A lot of parenting time schedules are nowadays are more on a 50-50 basis, but that's not always the case. But there are some common ones that we see frequently in court. So I just thought we'd share a couple of examples with you. When kids are younger, I'd say if they're infants, toddlers, or if they're elementary school aged, the courts usually like to have the children see each parent on a more consistent basis. And that makes sense, right? When they're younger, their attention spans are shorter. It's good to see mom and dad more frequently. So they get that more frequent contact. So a very frequent schedule that a lot of parents like, it's called the 2-2-3 schedule. So an example of this is the child will be with mom on Monday and Tuesday nights, dad with Wednesday and Thursday nights, and then they alternate the weekends from Friday to Sunday. So that's one example of a common schedule. When children get older, maybe they're preteens or teenagers, and they have a little bit longer of an attention span and can go a little bit longer time without seeing mom and dad so frequently, and they have phones and can FaceTime and all that good stuff. A week on, week off schedule is a popular option, and sometimes parents use this during the summer when they don't have school to worry about. So the parents pick a day that works for them to make an exchange. Let's say it's Friday nights, and they will exchange and have the child for whole week, 7 days, and then the other parent will get the child for the next 7 days. Sometimes if parents live far apart, a 50-50 schedule isn't logistically possible. So in those kinds of circumstances, sometimes the parent who lives further away from the child's school, they might get more weekend time or vacation or holiday time or time in the summer. And if we're talking about a parenting schedule, maybe where one parent has primary physical custody, then that kind of a situation might look like the non-custodial parent having a dinner visit or an overnight during the week and every other weekend. And so the custodial parent would have the rest of the time. Both types of custody, so both legal and physical, can be either joint or shared, or one parent can have sole custody. Physical custody affects child support calculations and where a child may be eligible for school enrollment, so that one is important. Parents can also have joint legal custody, with one parent being designated as having final decision making authority in the event that the parties can't agree on a particular issue. So, an example of this would be if mom wants a child to attend school A and dad wants child to attend school B, and they just are talking about it and they can't figure it out on their own. If mom has final decision making authority, then the child would attend school A because she has that designated authority. Otherwise, if there's no one with designated authority and they have just straight joint legal custody, if they can't make a decision, then somebody would have to file in court and have the judge make that decision for them. All right, Marty, you want to get into some of the factors that the judge considers in all of this?
Yeah. So, piggybacking on what Jolie said, it is up to, if we're talking litigation, the standard is the best interest of the child in both types of custody. So, the judge, as the decision maker, is going to consider the following factors. So, we're looking at what is the physical and mental health needs of the child. So, does the child have any disabilities or any sort of special needs that maybe one parent is more equipped to be able to handle? We really want to make sure that, or how the child will be in both of those cases. There's a range of things that are considered with this. We're also looking at what the children's routines are. So again, where they're in school, where are the locations of both of the parents going to be in the new world, and how can we keep consistency as best as possible. However, we also have to recognize that there's a shift that's happening. We're typically going from one household to two. So the court's going to consider how this is going to impact the routine of the child. And again, age is a big factor. If we're looking at an infant, it is going to look very different than if we're talking about a 14-year-old. So we just have to, it depends is a common phrase you're going to hear from us as attorneys and as your mediator, because it's so fact specific. But these are some general pieces. So, what are the children's ties to the community and school? How embedded are they? Are they on a traveling hockey team? I see that a lot. Or maybe they're in the dance program. They've been connected to the local Girl Scouts, whatever it is. We really want to look at how we can continue to cultivate that and keep the kids, again, with some consistency and regularity amidst this really difficult time. What are the relationship of the children with any extended family members who may be around? Or if they have half siblings, if we're looking at, maybe this isn't the time of the divorce, maybe this is a modification that we're looking at and they're looking at changed custody. All of these factors as to how they're connected to the extended family are going to be considered. So this is an interesting one. Preference of the child. And we just have to give a big caveat here that it is not necessarily that the child ever has the right to decide. And I hear this question a lot all the time. Okay, so what age does my child get to say, I don't want to go see my other parent anymore? And the answer is 18. That's legally the answer when a child gets to make the choice. That being said, the preference of the child can be considered as a factor in the weight of the decision. Now, if you've got, again, an 8-year-old that is absolutely resistant to seeing one parent, that might be treated differently than a 16-year-old who just is refusing to go. So again, it depends, but it is one of the considerations. We're also going to look at the physical and mental health of each parent. So, what is their ability to be able to care for the needs of their children? So, we're looking at, I think this is where a lot of substance use disorder may come in, any sort of diagnosed mental health issues that are not taken care of, right? So if somebody is, again, we don't hold that against people for any of these issues, but we just have to consider, how do the parents' situations impact care and the best interests of the child? If we look at the couple together, which parent was historically the primary caretaker, and more in many of these cases, we're seeing that split differently than maybe we did 10 or 15 years ago. So it might be shared, it might not be, but we're going to be asking a very detailed histories, particularly in litigation, when we're trying to decide, and the judge is going to want to know these factors. What are the parents' work schedules? So I hear this all the time. I want 50-50 custody. Great. So now we look at what the work schedule is, but we have one parent who may have been historically, maybe had parents' hours, and the other person worked much more of a 40 to 50-hour work week, if that parent who has that longer work week doesn't have the flexibility when we're looking at a 50-50 schedule, how do the kids get to and from school? Who's available on emergencies? Are you able to stay home with the kids on their sick days? Like all of these things have to be considered when we're looking at the custody piece. And again, back to the best interest of the child. Another piece that is important is how each parent is able to facilitate the relationship between the child and the other parent. The court is going to want to hear that we're promoting the other parent, even though you're getting divorced, and that the child is not being put in the middle, because all of the studies and what we know is that when the children are felt like they're put in the middle between the parents' disagreement and whatever's gone on, it is not in the best interest of the child. I think most judges agree on that. There's very few things most judges agree on, but most of them will say that putting the children in the middle and how you speak about the other parent and in front of that child is going to be considered if a judge has to make a decision. So I just want you guys to know this is not an exhaustive list, but the major risk of litigating is what Jolie said, is that a judge has very wide discretion. And I would argue, not is it only varying judge to judge, it depends on the day that you're in front of a judge. Like you might get a decision, a judge may really say, oh, I'm like, a certain thing is their thing until it's not. And then you just don't really know. Like sometimes they go and get extra training, or it just varies. They're humans. And so we're asking them to be very predictable and be able to really tell how they decide on things. But they change their mind. So anytime you're dealing with a contested custody case, you are leaving it out. There's so little control. And for the attorneys, there's so little control. We're doing the best that we can to present the case and all the factors for our client's best interests in the best interest of the child. Sometimes those don't always coincide either. Attorneys, our job is to zealously represent you as our client, but the judge is not deciding on either party. They're looking at the children. They're looking at the children. And I think that's really hard for a lot of folks to understand, particularly in these hotly contested cases. So that's where alternative dispute resolution, so like mediation, can come in, because we can have these conversations and we can work through really creative agreements that allow you to keep control of the decisions that are best for your family. Because I will say, Jolie may be able to agree that most people are not happy when a judge makes a decision, because they're not trying to make either party happy. They're trying to find that middle ground. And usually each parent is going to give up something, or it's not going to be ideal. I've seen some orders come down that we're all just scratching our head going, I don't think anybody suggested that. And that's what we have to live with. So it's something that to understand around that piece. I also want to just mention that it is worth noting that in Massachusetts, we do have a rebuttable presumption, which means that there's a presumption that you can argue against, that's part of the statute, that joint custody, meaning particularly joint legal custody, is not in a child's best interest in cases of domestic violence. So as somebody who litigated domestic violence cases for the majority of my career, that came into law. I can't remember exactly what year, but I was in the midst of litigating. And it is not as easy as folks think. We have to be able to demonstrate there is a pattern of escalating abuse or an extreme incident of physical violence for this presumption to apply. So I had many people who would say, so we don't have to share custody. And that's just not the case. And even around physical custody, the court can still make those decisions if it's presented. Both parties have an opportunity to present their case. So there's not a guarantee either way. So that requires a lot of expertise, making sure that you're working with folks who understand the dynamics around power and control, domestic violence. When we bring in coercive control, I think that's that's newer territory for us here in Massachusetts. It's a newer law that's just gone into effect, I think, within the last 2 years. So I don't know that we have a ton of case law around this yet as to how judges are applying coercive control in the context of this piece of it. Yeah. Oh, so then do you want me to do the relocation piece? Julie, you want to take that?
I'm happy to tackle that one.
All right.
And I just wanted to agree with you, Marty. I've had some temporary parenting schedules come back from the judge that nobody was arguing for. And we find out that they're completely unworkable for the parties. And so then us as attorneys, we're trying to figure them out and it just creates more conflict. So sometimes it just causes more problems than solving it, which is really unfortunate. So there's these cases in Massachusetts called removal cases and more commonly referred to as relocation cases. So if a parent wants to move out of state, out of the Commonwealth of Massachusetts with a child, you need to either get consent from the other parent, so an agreement signed by them saying, yes, this is okay and you can do this, or you need to seek a court order allowing the move. This is governed by a statute, Chapter 208, Section 30. And the standard that applies here depends on whether or not you have sole or shared physical custody. So, this is another area where the parenting time schedule is really important. So, if you are looking to move and you have primary physical custody of your child, the standard that applies, it's from a case called the Giannis case. And we apply, it's called the real advantage test. So the court is going to look at the parent's motivation for moving. Does the parent have good cause to move? Is the move consistent with the child's best interests? The court is thinking here, if, this move is going to be beneficial for the primary custodial parent, then it most likely will be beneficial for the child because those benefits will flow to the child. The court also does have to consider the interests of the non-custodial parent and the impact that the relationship will have on the move. But I guess what I'm trying to get across here is it's easier, lesser standard for somebody to meet to be able to get a removal order to move a child out of state if you have primary physical custody. Whereas if you have joint physical custody, it's a little bit harder. It's stricter standard that you have to prove. This one is from a case called the Mason v. Coleman case. This is just the typical best interest of the child standard. Here, the importance of the advantage to the parent who is looking to move out of the state is greatly reduced. And you simply have to look at all of the factors that Marty just went over and discussed. And also, again, look at the impact on the relationship of the other parent who won't be moving out of state. So it is a lot harder to get a removal order if you have a shared 50-50 parenting schedule with your co-parent. All right, so now we're going to move into some different terms you may have heard floating around. There are various custody professionals and processes that helps the courts and attorneys with this whole custody process in the family court. So you may have heard of this one. It's called a guardian ad litem, and it goes by GAL for short. And the guardian ad litem is appointed by the judge, and they are tasked with conducting an investigation. It's a very thorough investigation, and making recommendations to the court that are in the best interest of the children. And so usually they get about 30 to 35 hours to talk to the parties, talk to the children themselves. They do home visits, they talk to doctors, teachers. Each party can identify collaterals in their life they would like the GAL to speak with. So they really get a very holistic picture and comprehensive picture of what's going on in the family dynamics. And they file this report with the recommendations for the judge to consider. It's not binding on the judge, but it can be very persuasive. So the benefits of a guardian ad litem investigation like I said, is very thorough review. You're able to get a lot of information to the judge without having to go through the cost and time of a full trial. But some of the cons is it does delay your case a little bit. It can take 3 to 6 months or sometimes more for the GAL to complete their investigation. There is a cost associated with having a GAL appointed that the parties typically bear. Usually the parents split those costs. And sometimes you're not in control of who gets appointed as your GAL. And the skills of the GAL can vary. So sometimes that can be up in the air. Another professional who may be appointed in contested custody cases is called ARC counsel, ARC. This stands for Attorney Representing the Child. These are volunteer attorneys, family law attorneys, who are appointed to represent the child. They go to every court hearing and they are the voice of the children in court representing their position. They do not represent what is in the child's best interest. They simply tell the judge what the children's position is. So that is how it differs from a guardian ad litem. A benefit here, as I mentioned, is that they are volunteers, so there is no associated cost here. Sometimes I will say, though, in practice, it can take some time for our attorneys to be appointed because there's a high demand for them and not many volunteers. So I'll just add that. Each family court has something called a probation department, and sometimes a judge can order a probation investigation. This is like a guardian ad litem investigation, but it's much more condensed. It usually happens in the span of a few hours. They can talk with both parties, maybe the children. I've seen in my cases that I've had this used in, it's usually on a very specific, narrow issue. I've had cases where if the school choice is a contested issue, then the judge will order a probation investigation to make a recommendation on that issue. So it's more of a limited scope that I've seen it used for in practice. But if GAL is on your wish list, but maybe you can't do it for finances, asking for a probation investigation might be something you want to consider as an alternative. And then there are PCs, which are parent coordinators. Some parties choose to hire parent coordinators to use when they're not in litigation and to stay out of court. Some parties even agree to give parent coordinators binding decision-making authority. So if they can't come to an agreement on their own, the PC has the tie-breaking vote and they don't have to go back to court. Parent coordinators I found to be very helpful in high conflict custody situations. They spend a lot of time with the parties, getting to know them and the children, helping to facilitate communications with them, teaching them conflict resolution skills, giving them some parent coaching skills. A parent coordinator, if you're in a high custody conflict situation, may be something you might want to look into. When all else fails, if you've tried mediation, if you've tried negotiations, and you just can't get an agreement, there will be a custody trial. Children will not testify at trial. The words of children, including their preferences, may also be excluded as hearsay in trial because the judges have to follow the rules of evidence. So that can be tricky to get in sometimes. As Marty mentioned, there's no set age for children to decide where they want to live. Older children's expressed wishes may carry more weight. And in custody trials, judges are very wary of parental manipulation and influence. So that's something that they are on the lookout for. And I've seen a lot of commentary about that in post-trial decisions. Let's get into some tips for more peaceful co-parenting, Marty. That sounds like a good topic for you.
Yes, it does. Co-parenting can be hard. It can be hard under the best of circumstances, but especially when we have some of these high conflict cases. And as I said, in many of my cases, I had experience with this. This didn't exist when I got divorced many years ago. I wish it had, but we do have these things called co-parenting apps. And two of the most common ones that we see are called Our Family Wizard and App Close. I think there are some others, but those are the two that I see the most. And so, what these are is a way for you guys to have shared calendars, right? So, you can have the kids' calendars, you can communicate. That's where I saw it used mostly, was in communication. So, it's like texting. But the beautiful thing is that with texting these days, one of the problems is that you can't document it should you need it for litigation down the road. It's much harder to get in. The co parenting apps will actually allow you to not change what gets text and you can print it out as PDF so you can use it. The other thing that I really like about co parenting apps is that you can choose when to use it. And I had clients who, that if they knew that they didn't need to have constant contact with the other party, they could shut it down or choose not to open it so that they weren't constantly getting notified, particularly in these high conflict cases where if you go into your text or email and all of a sudden you get a text from your ex and it's not nice, it could just ruin your whole day. And so these co-parenting apps are ways to help put some boundaries around that, which are great. You can also use them as ways for kids to call the other parent. There's a lot of features in that. So there's ways that you can actually utilize these apps to help with the structure around co-parenting. So it's less charged, I would say. Another thing that we can do is helping minimize conflict during drop offs and pickups. So the exchange locations. One of my favorites is to do it during at school, especially if you've got some of these schedules where it's either a week on or a week off, or the 2-2-3 schedules, because you can arrange that during the school time, the kids go to and from or get picked up at school. So the parents never really have to have that interaction with each other. And that can be very helpful in many cases. So when we're crafting agreements, whether we're doing it in the context of litigation, and quite honestly, I think Julie referenced the trials, most cases settle. And that allows the attorneys or the mediator, whomever you're working with, to give you an agreement that's very detailed. And these details are really important. So we want to make sure that we outline holiday schedules, we outline drop offs and pickups, because if you don't have specificity in your agreement, it's very hard for the court to enforce. So the court is going to be looking for specificity. And then if you're in an amicable situation, you could always have, and any other times as the parties agree, there's some bucket language that we can put in there to give you, to allow flexibility, but always have a backup so that if you can't agree, you've got a default. Working with the parent coordinator, Jolie talked about that, but we also have these things called parenting coaches. So the parenting coordinators have some regulations around them with our standing rules in Massachusetts, but parenting coaches do not. So parenting coaches are a way to, there's some really powerful, amazing programs that are working to help you as the parents, the co-parents, create your own, like your business plan as to how we're going to co-parent. So that may or may not get put into your separation agreement, but you're able to work together to find out where the points of pressure are so that you can start to eliminate that and really find ways to communicate better. And it's a beautiful thing. I wish that even as a divorce attorney myself, if I wish I had that 18 years ago, I think I could have had a very different outcome. My kids are 22 and 26 now, so we've gotten beyond that, but it would have been nice to have a better relationship. So there's lots of things available to folks now. So the final thing I want to say about any of these things regarding custody, and we've talked a lot tonight, but know that nothing is set in stone, because anything regarding children is always modifiable. You have to meet a certain standard, which is a material change in circumstances, showing that something has changed. So just because you don't like it or you want it to, just isn't quite working out, that's probably not going to get to that level. But talking to somebody, a professional, is going to help you be able to understand. Sometimes over time, the parenting schedule that you put in when your kids are 2 and 5 will not be the same as 12 and 15. So if you're not able to work with your co-parent to be able to modify, you might have to go back. That's a material change in circumstances. So it's just, these are factors that you can consider, and know that what you put in now may or may not look very different over time. And if you are working with a mediator, one of the things I like to do is really help you craft an agreement that's going to expand over time and be able to grow with you and your children. But if it doesn't, that's okay. You have a remedy.
All right. Thank you so much for listening to Marty and I. And with that, we're going to turn it over to our home professionals, David and Maggie.
Thanks, Jolie and Marty. Thank you both. You guys did a great job. I always learn stuff when I'm listening. And I think, Tom, you want to come on too? The three of us can, I know as a financial advisor, the three of us are often talking amongst ourselves, coming up with the best plan for you all. But when there's kids involved and what we refer to as the marital home, which would be the home you jointly own right now, there's a lot of decisions to make, right? And a question we get a lot of times is, can I afford to keep the marital home and buy out your ex? And why would you want to do that? And usually the reason is a lot based on the kids and trying to keep the house for the kids so that they stay in the same schools, or just to keep some stability. Sometimes the numbers don't really support that as being the best decision. But we try to do, in my role as your mortgage loan officer and as a certified divorce lending professional, is to help you come up with, can you afford it? And even if you can afford it on paper, does it make sense? Maybe it makes more sense to purchase new. So those are the things we talk about a lot. I'll bring Tom in to help you figure out, does it really make sense for you to keep the house? Can that be sustained for that long? bring David in on staying in the same neighborhood for the same schools. I can share more, but Tom or David, do you want to share a couple things?
Yeah, I collaborate a lot with professionals like Maggie and David on running the numbers. I like to get to see the big picture, what's going on with every cash flow in that person's life, social security, potential child support, alimony, part-time work, full-time work, all those cash flows. How quick will you burn that down or not if you decide to buy out? The parental home is usually one big calculation that Maggie and I in particular are working on, and tapping into professionals like David, see what those numbers look like. And yeah, running those in some detail. And then we run different permutations by each other. Keep the home for a few years, keep it longer, go and rent instead. David helps us with the market analysis on that. What does that all look like? And we want something that doesn't just get you through the transaction of divorce, but we want to make sure you've got a sustainable lifestyle into the future, all the way through retirement and beyond. So that's where I come into play. David can talk about his role in the market analysis, I'm sure, and how that looks like, and renting versus buying, etc.
Yeah, so generally, my role in these cases, just as I would with a person looking to buy a property, it's still actually, we want to chat with the CDLPs and the financial advisors first, and the attorneys involved. We want to make sure that if I'm getting involved to list the home or sell the home, that we've exhausted all other options. We're not just jumping to the conclusion of let's sell the house. If that's the option everyone's agreed to, excellent. My role in those cases would be providing market valuations, which a common question I get is, are you a licensed appraiser? And no, I'm not, but there's a big difference between an appraisal and what I like to call like a fair market valuation. And all of these are opinions of value. If you look at the appraiser's guidelines, the true market value is what a property sitting on the market for an adequate amount of time is going to receive. So no one can tell you exactly what that house is going to be worth until it sells. Appraisers are usually looking at what is sold in the past. I do a little bit more proactive work on what's active, what's under contract, and what's not selling now, giving a live pulse on the market. So if I'm looking at other similar homes and going, hey, look, here's a very similar house. They're on the market for 3 months. Things are slowing down in pockets here and there, and depending on the price ranges and the condition, that might impact what my recommendation or my opinion of the price would be. So we provide that, and that number can be used across everyone involved with the attorneys and mediators, and provided to the court if needed. We do offer options. As a part of my designation as well, as I won't try to go too far down a rabbit hole on this, but we have a higher code of ethics than traditional realtor does have. So one of the things we do is we don't practice dual agency. So anyone involved needs to purchase, needs to rent at the same time. My goal is to reduce any type of bias so that both parties involved are not assuming that, oh, you're pushing things along to just close the deal. That tends to be the issue with most traditional realtors, is they know one person or the other, or they're just very eager to close. I'm eager to make sure that everything's compliant with what everyone's agreeing to, and however that looks along the way. So if someone is in a position to purchase and they can, I have another teammate that is also a CDRE. We go back and forth. So if someone's buying, they would work with one of the folks as a buyer. If I'm representing the house, I'm representing the house, and that's it. I'm not doing more than that. Rentals can also be an option as well. I know a lot of the times in these situations, credit can be a little challenging. I do have some credit repair experts in my field that will help people rebuild that either during or after the fact to get you in a position to buy again. But anything involving that relocation, and it's like what we do. We try to have our resources out to help with that. A couple other things that I was taking a few notes on the topic of custody too, is I like to really make sure when there are custody arrangements in place, if we are selling the house, I'm keeping in touch with the attorneys and making sure what's that family plan look like, because if there are certain days that the children are not going to be at the house, I'm going to try to make sure that any showings or appointments are blocked in that time frame, because we don't want to add any additional times that everyone's being vacated from the property for showings, open houses, appraisals, inspections, and things like that. My role is keeping in touch with counsel and the parties directly to make sure that I'm up to speed on what the agreements are and how we work that into moving a sale forward at the same time.
Yeah, that's great.
I think one thing we haven't stressed is the importance of building your team ahead of time, ahead of the divorce. Don't wait till you have a divorce decree and that says, oh, one spouse is going to refinance and buy the other one out or do this or that. What if you got to run the numbers? Is that refinance possible? And that's where Maggie in particular will come in there on that and figure out, is that feasible for you? Are you going to get approved for that? The earlier you can start building your team and discussing all these various options, the better. Don't leave it till the last minute. You get some really fantastic advice and see your options up front early in the game.
Yeah, that's a good point, Tom. One of the reasons I ended up getting my certification in the divorce lending is we'd see that all the time. People come to us with a divorce separation agreement finalized, and in there is for one to buy out the other or refinance it or these different things, and then also child support, alimony. But then no one took the time to, like you said, get a loan officer to look at it ahead of time. And unfortunately, sometimes what's been agreed upon isn't actually possible. And so the whole point of, like Tom said, having the team ahead of time to look at it together is so that when you're coming up with that final separation agreement, then it's really executable, is how we put it, right? We want to make sure when you sign on the dotted line that we can then go and execute that. One thing I want to talk about too is how child support, just on the topic of kids, how child support can impact your ability to be approved on the mortgage side. So if you're someone who's going to be paying child support, so it's your obligation to pay, and let's say I'm helping you figure out numbers. I'm actually helping a client right now where he's hoping to stay in the marital home, but he's also going to be the one paying child support. And we have to factor that in as a monthly obligation for him, and along with his car payment and the new mortgage payment and everything, other credit card payments, things like that he might have. And so like right now it's a little tricky, like he doesn't quite qualify. And so we're looking at some different ways to do that. And then on the flip side, maybe if he's going to go and purchase something, again, we're factoring in that child support. But then you've also got the case where somebody might be receiving child support income from the divorce. And it's not, a lot of times we have couples and they're going through mediation and they really want each other to be successful after the divorce. And it might even be a matter of, if X amount was the child support, could the person who wants to stay in the home and is going to be receiving that support, could they use that to qualify? And so that can be part of the conversation. I can look at proposed, if this is the child support number, does that work? When can we use child support for income to qualify? As long as it's been received for 6 consecutive months, so the same amount consistently for 6 months, then we can start using that income to qualify. So in cases where they're going through mediation and it's decided very early on that there's going to be child support, and say Marty calculates that and Tom with you and you've decided it, the party that's paying child support could start it immediately, even though the divorce isn't finalized. And that just gives us a kind of a head start on using that income to qualify later. So all these things we take into consideration. I also want to mention, sometimes I want to keep the marital home for the kids. It's an emotional time. And as Marty and Julie were talking about, that best interest of the child, how it can be looked at differently with different judges. Also, different parents see that differently. And just because you're going through this emotionally, sometimes you're just very convinced that this is the best thing for the kids to stay in the house. But if it's going to financially tax you where you're to the point where you won't be able to afford any of the other lifestyle things they're normally used to, it might not be the right choice. So really doing the numbers with me, and then Tom does a great job looking at your total budget and thinking like even utilities and all those things, and really how much money are you going to have every month. Those exercises that we do, yeah, I always say the math helps you make the emotional decisions, right? We do the math together. The math doesn't lie. It is what it is. And then that can help you make those emotional decisions and figure out what's in the best interest of the family. Guys, anything else to add?
Yeah, we're not telling you what you have to do. We're just laying out your options from a kind of non-emotional point of view. Of course, we understand that you want to keep the kids as close as possible, but we're just going to lay out the numbers and you end up ultimately making the choice. But the bigger picture we can get, the better. things that I look at, future inheritances, like things that are beyond just the transaction, your ability to do part-time work, all those cash flows, if I can pull those in, the better. And looking at the budget, things that you didn't think of. If you keep the home, what's it going to look like for maintenance? Who's going to do the yard for you? If you had your spouse do it before, who's going to do the cleaning the house if your other spouse did it? All those factors come into play. So the more of the big picture we can build up, the better.
We didn't talk about, I know Marty and Julie, did you touch on nesting? That was something that we talked about that comes up a lot. That David, you might be able to chime in too, that sometimes you've got a situation where a couple decides to, Marty and Julie can better describe what nesting is, but if you were doing that, you were living where the kids are staying put all the time. Some people have chosen to rent an apartment where when one parent isn't there, they're living in that apartment, right? And they're continuing to keep the marital home in place. And there's some different ways to go about that. But thought I'd bring you ladies back in. I don't see many questions in the thing. Don't forget that you can put questions in the question and answer section, and no one else can see your question. So except
Yeah.
for us on the panel.
Yeah, don't be shy. We
Don't
got
be shy.
8 questions. I'm not seeing them today. It is
Alright.
confidential. So
Yeah.
fire them at us. We love to answer them in real time.
But bringing
So
you
nest-
back to you, Julie.
Yeah. So nesting, in practice, I see it used more as a short-term agreement in temporary orders, or as a short-term financial solution while everyone's figuring out where they're going to be more long-term. And so the idea is that instead of the kids having two places that they're going between, the children stay put at the marital home, and it's the parties who are coming in and out of the marital home. So you're exactly right, Maggie. Sometimes they choose to rent an apartment where the party who's not in the marital home, they'll rotate in and out. Other times they might have family members that they might be able to stay with, or other arrangements that they're able to make in the short term. I don't see judges ordering this unless it's agreed upon by the parties, because something to think about with this kind of an arrangement is that you really never have your own personal space. You're still sharing the marital home with your partner. And then if you are sharing an apartment, you're still sharing that space with your partner. So it can be beneficial for the children because they have they have their consistency, their routine. They are not experiencing disruption except their parents coming and going at different times. But I think it's the lack of any kind of privacy that is really the biggest downfall. But it does have great financial benefits, which can really help in the short term.
That's great, Julie. And actually, we have a question regarding moving out. If I move out, does that influence child custody agreements?
So I'm going to pull a Marty here. It depends. Yeah. So my advice to my clients is that if you have young children, you don't want to move out until there's some clear expectations with your co-parent about what the parenting time schedule is going to be. If you have a case filed in court, if your divorce is filed, I would prefer that my clients have a stipulation that everybody signs saying what the parenting time schedule is going to be, and we make that into a temporary order. If you are working with somebody like Marty and you're mediating, then you can talk about your process, Marty, but you would talk about this during your session and make sure everybody wanted you to talk about it. Yeah.
Yeah, that's one of the first things we do if folks are still living together. It's, do they want to stay living together, or do they need to actually create a plan so that they can live separate? And that's one of the first questions I ask, because the stress of living together while you're trying to do a divorce can be really difficult, but both people are afraid to leave for various reasons. A lot of times they haven't even told people yet. And so that's the first thing we're talking about, is we got to tell people, and then we want to have a plan in place so that we know what we're doing. So often in mediation, the first or second session is spent significant time really trying to co-create that together so that we can do that. And when in the litigation world, again, I agree with Jolie. If you have access, you've got to have some sort of access to your kids. You got to make sure that there's some sort of, both parties can have access. But sometimes people do have to make a choice to leave. They have to make a choice to leave sooner than, for a lot of different reasons. So I think that right back to Julie's answer, it depends. really talking through someone specifically about your case to determine what the best course of action is. But we don't want people to stay in situations that are either unsafe or just tremendously unhealthy. The question that follows, it wasn't asked, can I leave with the kids? That's a different question because, yeah, that's a different question.
Also, alternatives that there's some motions that you can file in court asking for your partner, your soon to be ex, to be vacated from the home, or for you to have sole use and occupancy of the property so you could stay in the property with the children and they have to leave. So there's some options there. But I think the point that trying to get across is the best case scenario would be if there could be clear expectations for everybody, because what we want to avoid, and this sometimes happens, is, one parent will move out thinking that they'll just be able to come and go and be with the kids as they please. And the parent who's in the home either blocks access or really makes that difficult, and it increases conflict. And you can't really get any clear guidelines until you get into court, which can take a while. The court process can take a while. I would definitely recommend that you consult with somebody before, or hire a mediator, or talk with an attorney before you make any of those plans. Unless it's a life-threatening situation, unless it's a safety situation.
Great, good answers. And we have another question here for financial planning. What if my husband is hiding assets or accounts? Tom, did you?
Yeah, I could take that one. First of all, some cheap ways I'm looking into that is looking at taxes, looking at pay stubs, looking at statements, if you have access to those, to see what's going on, tracking that movement of money. In some cases, however, we've had cases as egregious as one person took off and took every financial statement out of the house, cleaned everything out where the person had no access to any of that information. I'm going to turn it to Jolie in a second. That's where your lawyer can come in and start subpoenaing documents, etc. Jolie can talk as well about against temporary orders to prevent assets being dissipated. I also want to mention, though, that we have people, forensic accountants, that we can tap into at Vesta as well to start tracking down that. If it's within your budget, you can bring forensic accountants into place here that are trained in seeing the tricks of the trade here, including movements with crypto, etc. in the case of divorce. But Jolie, you can chime in there on some of those orders you might have to get in place and some of those subpoenas you might have to do.
Yeah. So if a divorce is filed in courts, then there are automatic disclosures that both sides have to provide to the other parties. These include things like 3 years of tax returns, 3 years of bank statements, and there's a list of other documents. And these have to be provided to the other side. And so if the other side doesn't provide these, you or your attorney could file a motion to compel, and that is a specific process where there could be sanctions or consequences for the other party if they don't provide those documents. But yeah, there's a really great discovery tool called a subpoena that you could send directly to the financial institution. So if you know that your husband had accounts at Fidelity or E-Trade or whoever the institution may be, you can just go, you don't even have to involve them. You can just send a subpoena directly to the institution and get the statements or documents sent directly to you, so you don't even have to involve them. And then if you need to take it up another level, a forensic accountant is definitely would be the next step. But there are resources depending on the level of lack of transparency that's going on.
Yeah, we have experience as well with some of the other tricks of the trade. If they're friendly with their employer, delaying bonuses, etc., to make their income look lower, or delaying a business contract. Some people paying friends of family on the payroll, especially if they have their own business. We see those kind of tricks. We have some experience in looking out for those kind of things that people will use to lower their income or hide assets.
Yeah. So the parties have to exchange financial statements. And if a party is self-employed, then figuring out what their true income is takes a few hours of a deep dive because you're going to want to see if they're putting any personal expenses through the business. You want to see if they are using any depreciation on assets in the business to reduce their income. Any kind of self-employment definitely takes more of a deep dive than if your ex is just a W-2 employee.
Good answers, team. This is why I love this team. Another question, is the marital home a big factor in deciding joint physical custody? And is it worth keeping it if financially taxes the parent? I'll take the second part real quick. Is just is it worth keeping it if financially taxes the parent? That's a really great question. And that's why like doing all those numbers and that Tom and I do to really come up with what's the true monthly cost going to be and how is that going to impact your daily cash flow is crucial. The first part of the question, is the marital home a big factor in deciding joint physical custody, Marty or Julie?
Yeah, I think that again, it depends, but in the environment that we're in now, particularly here in Massachusetts, judges understand that keeping the marital home is not always financially reasonable. If there's equity, somebody's going to probably have to buy the other person out. There's likely going to be a higher interest rate, all of that. So the fact that one person can or tries to keep the marital home doesn't necessarily, it's one of the factors because we're talking about the kids' routines. But I think judges are more and more understanding that the kids are going to have to adapt to what the new reality of the world is. And oftentimes selling the marital home just isn't, it has to happen. Like it's not, again, asking that second question to really ask somebody to sacrifice so much to keep that doesn't end up being in the best interest of the kids a lot of the times. Maybe 20 years ago, that would have looked like a different scenario, but we also had a very different time then. I think that it's less of a consideration now. We're looking at the overall picture of all of the pieces, in my experience.
And I just want to say that some of my clients have found it to be helpful to get a new space to call their own. There can be a lot of memories in a marital home, and finding new space that you can decorate the way you want and that kind of has a fresh start. I've had clients when I catch up with them 6 months or a year after their case is settled, they've told me that it's really been like a breath of fresh air and they've made it their own. And this is coming from some people who really were either sad or wanted to keep the marital home, and sometimes it turned out to be a blessing in disguise. So I just like to offer a different perspective.
I would just
Really, many
add,
of my clients will say that. I hear that. I hear it creates a new boundary too. Client said that at her other house, the ex used to just walk in when he was picking up the kids, and now at the new house, he waits the driveway. So it's just a new boundary. Yeah.
Mhm.
Or the same.
The other thing I hear a lot is people are doing it for the kids, but that may not necessarily always be in the best interest of the kids, right? Because again, there's consistency, but maybe that new environment could be better for them. It doesn't like we assume that place is going to have that consistency for kids, and I think that we find that might not necessarily be always true. So again, it's fact specific. Every case is unique, but I've had so many clients that hold on to that because that's the belief they have. And then they realize this actually isn't, like the kids need a new place or they get a new place with the other parent and they adapt. And so that rigidity around keeping that asset, I think can fluctuate and maybe be a little more flexible sometimes.
Agreed. We have another question here. What does child support usually entail?
So, child support in Massachusetts is determined by a formula called the Massachusetts Child Support Guidelines. You can go online and Google this and probably find it's a PDF, it's a fillable PDF, and you can play around and enter some numbers and get an idea for what the child support order may be in your case. The most important things that you need to know to determine what the child support order would be is number one, the number of children. So that's easy to determine. Are they over the age of 18 or under the age of 18? In Massachusetts, in certain cases, child support can continue until the age of 23 if children are still enrolled in college programs. Child support is reduced between ages 18 and 23. Also, the physical custody. What is the parenting time schedule? So there's different boxes. And so if you are the primary physical custodial parent, you'll check one box. Or if you have a shared, more of a 50-50 parenting schedule, you'll check another box. And then you'll enter the gross incomes of both parents. So this is before taxes are taken out. And these are all weekly amounts. And then you can deduct for certain expenses. Those are health insurance, what you pay for health insurance premiums, dental and vision insurance, and then also child care and child care expenses. So you can plug in those numbers. The formula is built in to the worksheet, and you can see what the default child support amount would be in your case.
And I just popped that worksheet in the chat for folks.
Thank
It's
you.
right on my saved bar. I use it quite
Mine
a
as well.
bit.
Yes.
And what I will add is that, as Jolie said, we're calculating it on gross, so pre-tax, or what you're not what you're taking home, but the person who receives it is not taxed on. That is after tax dollars. They do not get taxed. So just
Very
something to
important.
consider. Yeah, it's very important. I was just talking with a client today, and when we look at, I think it's 30 something $1,000 a year in child support based on the calculations, that's going to go in their column as non-taxable money, which is as Tom and Maggie, you guys are probably, that's a big benefit.
It is. Yes. Yes. Absolutely.
For
I
sure.
want to read some of these questions from that we got ahead of time that we haven't addressed yet. This one says, my ex-husband has shown a pattern of skipping child support on some weeks. Do I address this at probate or coercive control at the local court? I am paying the lion's share of travel expenses for children's club activities, e-bike. My parenting time is there. If I file for him to share in the cost, it will open a whole host of issues like retaliation and rage, which could put us in even more stress and issues for us. What to do? What should I do? I know sometimes, Marty and Julie, you guys do answer things one off, so this might be a good, but I think what the general kind of opens up that you were talking about material changes of circumstance, because this seems like they're already divorced, maybe?
Yeah,
Yeah.
he's
So
looking for that for modification. But then there's the contempt issue too. I heard three. There's a contempt issue, there's the coercive control, whether that's trying to get a restraining order around that or a modification. And all three, so that you could be looking at three different matters that could go in the probate and or maybe the district court. But the other piece I think that is really interesting is that last piece of, is it worth it for me to open that up? And I think I spent a lot of time having consultations with people around that to really understand, what does the process mean? What are you potentially looking at, both in cost if you're going to hire a lawyer for litigation, or even for your own going back to court? What does that mean for you, for your nervous system to be doing this? And what are the potential consequences that the person that you're dealing with, especially if you've already gone through the divorce and you've already gone through litigation? So I think that, yeah, I don't necessarily think I could answer those here, but I think having a consultation with someone would be a really good idea for that person, whoever asked that question.
Yeah,
I
agree.
agree. I will say that I've had some clients in the past who have not wanted to have to do the whole reimbursements for the extracurricular activities and the uninsured medicals and all of that rigmarole. And so I've been able to work out some agreements where the payor of child support, we've done like an upward deviation of child support to be a catch-all for all those extras. And it's just built into the weekly child support. So that way it's just one payment every week. And that seems to bring it's just less back and forth between the parties. It's just more efficient. But this person would have to deal with the enforcement issue, it seems like, with the contempt, but just an idea to think about.
Yeah.
Good. We've got a couple more here, which I know we have about 4 minutes left, but these could be good for everyone. Just how to get 100% custody of a young 15-year-old from her father. He's always working long hours. Is that something that you guys touched on that with the preference? But if there's any reason for harm or something, what do they do in that case?
I will say, in the Commonwealth of Massachusetts, it is extremely uncommon for any parent to get 100% physical custody. Even in extreme circumstances of neglect, abuse, substance abuse, I've seen very limited parental contact for another parent under very strict conditions like supervision and testing and lots of red tape. But it's very unlikely that a parent wouldn't have any contact with a child. So I think
Even
that
in
just
jail.
yeah, even yes, incarcerated parents. So I think that
Yeah.
just without knowing more, just a long work hours, I think that would be unlikely.
Well, we have what are some important and often forgotten items we should consider when developing a co-parenting contract?
Holidays, making sure that you're really thinking about like the holidays, school vacations. We include that when we're doing separation agreements. And I would hope that the court does those details. Again, you want to have as much specificity in it and flexibility. And there's ways to really create agreements that are both that so that you have the fallback if you can't agree. But if you want to be flexible and give yourselves that bandwidth, you can do that too. But I do think transportation is a big one. Who's transporting kids to what? Who's responsible for what or what parenting time? And holidays are ones that I see a lot that people don't necessarily give the time and consideration to when they're doing it themselves.
And I'd add to that the children's birthdays sometimes don't
Mhm.
get considered as a holiday, but it's a special day that a lot of parents tend to care about and wish to see their children on. School vacations, passports. Who's going to be the keeper of the passports? How are we going to renew them? Who's going to keep them? How are we going to exchange them? Travel, like providing travel details and itineraries to the other parents. Those are some that come to mind. Summer camps. How are we going to agree on which extracurriculars to sign up children for? Things like that.
Yeah.
Those are good. And anyone who's done a question ahead of time, and if we didn't touch on it, we'll make sure that someone from the panel who's appropriate to reach out will reach out. One other question though here, guys, does this information pertain to unmarried couples as well? Which I thought I'm curious because what do you do when you're not necessarily going through a divorce, but you are no longer together? And is there a way to set up those child agreements?
Yeah. It's a different statute, it's 209C, but it's still the standards apply. So instead of filing for a petition for divorce, if you're in court, you file under this parenting support and whatever it is, custody parenting and support order. But we use the same standard. So all those factors that we talked about are going to apply. It's the best interest of the child. The one difference I will say in Massachusetts is that if a couple has never been married, and the mother, under the law, it has sole legal and physical custody until a judge or court makes a different order. So that's a difference versus when parents are married, they both have joint, right? Until something is separated. But and again, lots of factors go into consideration when a court is making an order, but that is something that is not every state is that, but Massachusetts, even if the other person is on the birth certificate, the mother still has sole legal and physical custody. But that father when they're on the birth certificate, they can immediately file. They don't have to prove paternity. It's already assumed. And then they can ask the court to make decisions regarding their rights. But you have to go to court. You have to activate your rights where you don't in divorce.
Like I said, I always learn on our webinars together as well. I know we're right at the 8:00 time frame. I don't, Julie, if you want to wrap us up or.
I think there is
What?
one last question there
Yeah.
if we have time. How can you ask for holidays, etc., when you only have a temporary order?
You would, if you can't come to an agreement with your co-parent, you would file another motion for temporary orders asking for the court to set a holiday parenting time schedule. So that would be the proper procedure. Thank you so much to all of you for sticking with us through the end. We hope you found this session to be valuable. And we did put all of our contact information in the chat, so please feel free to reach out. And Mandy and her concierge team will be reaching out to you. So we hope to be speaking with some of you soon. And thank you again. Have a great night. Take care.